Hello and welcome to the Alliance for Home Health Quality and Innovation's Learning Collaborative webinar on legal and regulatory developments in home health care. My name is Teresa Lee and I'm the Executive Director of the Alliance. As you know, the Alliance was founded in 2008 and is a 501c3 dedicated to the mission of leading and fostering research and education on the value that home health care has to offer to patients and the entire U.S. healthcare system. Today's webinar is part of the Alliance's Learning Collaborative series. The Learning Collaborative webinars seek to offer information and perspective to help home health providers navigate healthcare delivery system change and reform. The webinar today will focus on legal and regulatory developments in home health. And we're so fortunate today to have as our guest speakers Bill Dombi and Mary Carr from the National Association for Home Care and Hospice, or NAHC. Mary Carr is Vice President for Regulatory Affairs at the National Association for Home Care and Hospice. In her current position, she represents home care providers before government agencies and other national organizations that impact home care. She provides regulatory and operational guidance to home care providers on a daily basis, writes for NAHC publications, and presents educational seminars. Mary has over 25 years of experience as a registered nurse in a variety of health care settings, which include acute care, managed care, and home health care. Her positions in home care have included Director of Quality Improvement, Manager of Staff Development and Employee Health, and Field RN. Mary holds a Bachelor in Science of Nursing and Master of Public Health. Bill Dombi is Vice President for Law and Director of NAHC's Center for Healthcare Law, Executive Director of the Home Care and Hospice Financial Managers Association, and Executive Director of the National Council on Medicaid Home Care. Bill specializes in legal, legislative, and regulatory advocacy on behalf of patients and providers of home health and hospice. With over 37 years of experience in healthcare law and policy, Bill has been involved in virtually all legislative and regulatory efforts affecting home care and hospice since 1975, including the expansion of the Medicare home health benefit in 1980, the formation of the hospice benefit in 1983, the institution of Medicare PPS for home health in 2000, and the National Healthcare Reform legislation in 2010. He has also been lead counsel in a diverse array of landmark lawsuits on behalf of NAHC. Bill has authored many publications and has spoken on a diverse array of topics involving home health care, and we're fortunate to have both him and Mary with us today. Just a few housekeeping notes before we get started. First, Bill and Mary will present for approximately an hour and 15 minutes, and will leave the last 15 minutes for Q&A. Please note that this is a webinar, and we control the slides on our end, so do not be surprised if you can't flip ahead. Your lines will be on mute. Please do submit your questions through the Fuse webinar software chat box on your computers or other devices during the presentation. And you can send a question to the speaker by sending a question to me, Teresa Lee, and I will read the question to our speakers. Finally, we will be posting the slides on the Alliance's website immediately after this webinar, and we're also recording the webinar and will post the playback on our website when it's available. Without further ado, I'm going to turn this over to Bill and Mary.
Teresa, this is Bill Dombi.
Great, go ahead.
Thank you, Teresa. This is Bill Dombi, and I have Mary Carr with me here at the NAHC offices in Washington, D.C., and we hope we can hopefully we can have a good program with you today. I'm not sure what the background messages are we're getting, but anyway, we'll move on to the program focus. We have several areas we wanted to cover today. One, issues in regulatory and legal matters that are affecting private pay home care as well as Medicaid and Medicare home health agencies. A focus brief on Medicaid home care issues that are developing, and but most predominantly on Medicare home health services. As it relates to private pay home care, while also affecting Medicaid and Medicare home health agencies, the number one issue that's out there today is the upcoming rule which eliminates the companionship services exemption under the Fair Labor Standards Act. The rulemaking that the Department of Labor engaged in last year also will affect live-in services of domestic care services. The rule was issued by the Department of Labor after an extended period of reviewing public comments. More than 10,000 comments were submitted, but it's only the most recent chapter in the issue relating to minimum wage and overtime compensation for personal care attendants. A change in the Fair Labor Standards Act in 1974 was implemented in a 1975 regulation that has remained virtually unchanged since 1975 until this recent event. However, between 1975 and today, we had seen a number of different matters going into federal district court. In fact, we had 2 lawsuits that went all the way up through the Supreme Court, as well as some attempts through the regulatory process to change the rule. This Department of Labor, with the significant support from the President, did ultimately change the definition of companionship services and also eliminated its application of the exemptions to any third-party employed worker. Third-party employment is the status that workers have that work for home care companies as compared to a direct employment with the consumer of the services. The rule eliminates that exemption for third-party employment, but also redefines companionship services in a manner that virtually makes it inapplicable to home care services paid for by any government program and probably in most cases not paid for on a private pay basis as well. That definition today until January 2015 defines companionship services to include personal care services, protection, and fellowship with limited allowance for housekeeping. The new definition would limit the ability of the worker to provide any personal care or housekeeping to no more than 20% of the time. As it's probably very apparent to all of you, that is not something that Medicaid pays for. It's certainly not something that would qualify as a Medicare home health service, and most private pay consumers are not buying simply fellowship. There is a lawsuit that was filed challenging the validity of that regulatory change. NAHC is one of the plaintiffs in that lawsuit. It is here in federal court in Washington, D.C. It is in the midst of briefing, at this point, motions for summary judgment on both sides' part in hopes of getting this resolved before January 1st, 2015. We expect that the Department of Labor and its lawyers at the Justice Department will vigorously defend the validity of the rule. We will be reminding the court that in 2007, 9 justices of the Supreme Court validated the standard for application of companionship services exemption to home care services and third-party employers. So we expect it to be a fireworks of a litigation show in that regard. Home care agencies that are affected by this are still well advised to prepare for the actual implementation of this rule in January 2015. A side note on a legal aspect of the Fair Labor Standards Act, there has been a significant increase in private litigation against home care companies, large, medium-sized, as well as some small ones, on wage and hour issues under the Federal Fair Labor Standards Act. Agencies should really be careful in evaluating their compliance under both federal and state wage and hour laws, looking at the issues of the exemption, but looking beyond that. The litigation has focused on a wide range of compensation issues, including the calculation of the hours worked, and within that, counting whether or not the hours of transportation between one client, one patient, and the next are hours worked, whether documentation time is hours worked, whether the nurse who logs into the company computer before she goes out on her first visit has started the time clock at that point in time. It is also focused in on the application of these existing exemptions, whether the person is providing companionship services or is providing a higher level of care that fits into a medical realm, thereby negating the application of the exemption. And a lot of the state law-oriented claims are focusing in on break time rights and lunchtime rights. So very, very active area by the plaintiffs' bar with group actions against companies providing care. The last one that I hadn't mentioned is per-visit reimbursement with Medicare home health agencies, per-visit reimbursement to professional staff. It can be done right and it can be done wrong, and that's what this litigation surge that we've seen focuses in on significantly, and they have already had some successful lawsuits on behalf of the plaintiffs against some of the larger home care companies. What do we see from all of this? On the companionship services rule, we do see business changes of significant nature just to bring about compliance or to avoid non-compliance. We see higher staff turnover. We see a shift to part-time workers. We do see Medicaid seriously implicated into this, and the National Association of State Medicaid Directors, along with the National Council of Disability, have asked for the Department of Labor to delay the rule for 18 to 24 months. Medicaid programs are starting to react. Governor Brown in California attempted to limit the workers of personal care services under their state Medicaid program to no more than 40 hours, but there was a major effort by the Service Employees International Union for the governor to back off of that. In the meantime, the Centers for Medicare and Medicaid Services, the federal arm of Medicaid, has put out recent guidance to the state Medicaid programs about their responsibility under the companionship services rule changes, and gave them a series of guidances on how they could operate personal care services in consumer-directed care programs without being labeled as joint employer. But the reality is the Department of Labor has also issued guidance which will make virtually all of the existing Medicaid consumer-directed care programs in some form or fashion joint employers with the consumer, and thereby implicating the Fair Labor Standards Act, whether those programs are through a public authority model or through a fiscal agent model or even through managed care. The Department of Labor's position is that it's likely to see a finding of joint employer status. Next slide is on the employer mandate. We had done an analysis demonstrating that home health agencies, hospices, but most particularly Medicaid home care companies and private pay companies have some serious concerns relative to responsibilities and obligations under the employer mandate part of the ACA. The President most recently delayed application of the employer mandate for another year for all employers of 99 or fewer full-time equivalents. That does give some comfort to the very small home care companies, but many of the home care companies have well over 100 FTEs, and there are changes to that phasing in the employer mandate, but it still results in a significant risk of a penalty to the home care companies, significant cost of health insurance to the home care companies if they want to avoid the penalty. We do find that the Medicare and Medicaid companies are not comparable in terms of their risk factors. More Medicare home health agencies do offer health insurance to their workers, while most Medicaid home care providers do not, and almost no private pay home care companies offer a qualified health insurance plan that would meet the employer mandate. We have activities ongoing in terms of advocacy in that regard. At this moment, primarily focused around a delay of the implementation date. A bill was dropped in Congress this week by Congressman Daines out of Montana that would delay the employer mandate for all Medicare and Medicaid dependent providers of services, defined as those that have 60% of their revenue or more coming from Medicare and or Medicaid. Not expecting that legislation to actually get passed this year because of the partisanship over this issue and the stances taken in the election campaigns that are ongoing, but it does put the federal government on notice that they may be one of the larger employers of low-wage workers without health insurance in an indirect way through their financing of Medicaid and Medicare. A number of business options are set out on that next slide that companies are exploring at this point in time, but I would advise that anybody who's looking at making business adjustments to address the ACA's employer mandate do so with good skilled counsel and good HR advice, because it's no doubt that it is a complicated matter that lends itself more than pretty much any other that I've seen in a while to very employer-specific kinds of evaluations and remedies. Last comment to make on the employer mandate is that Speaker of the House Boehner is looking to get approval from his Republicans in the House of Representatives to file a lawsuit challenging the President's exercise of power to delay the ACA employer mandate. While most of the Republicans, if not all of them, favor an elimination of the employer mandate, right now our best hope for some short-term remedy is another presidential order for a set of delays on the employer mandate. So we don't know whether that lawsuit will in any way help or possibly hurt the extension of delays that we so desperately need. On the next slide, we move towards Medicaid home care. And just a couple of quick words on Medicaid home care, in that we are seeing operationally, regulatory-wise, with CMS very much in the effort to make this happen, a move towards Medicaid-managed long-term services and supports. There are already over 20 states that are looking for approval for demonstration projects to use managed care to provide home care services to dual-eligible Medicare and Medicaid beneficiaries, and even a greater number of states that are moving to take their Medicaid long-term care services and put them into managed care. That is a potential mixed blessing for home care, dependent totally on how the plans actually unfold their involvement. There are early signs as some plans see the value of home care services as a way of avoiding higher cost institutional care and exacerbation of conditions leading to high cost inpatient care and the like, and there are other signs indicating that some plans are simply seeing their best success tied to reducing payment rates and restricting utilization of services. So it's going to be a time to watch and see. A number of regulatory issues developing from that include how the transition plans are developed, what happens with the existing fee-for-service providers, how long the clients, the patients in the Medicaid program get to remain with their existing providers, what's the payment rate process, what's the network arrangement that needs to be set up with the managed long-term service and supports plan and any provider network. So there are quite a few issues. But the other point I want to leave you with on that shift to Medicaid managed care is that the plans, as it's noted in the next slide, are pretty much flying blind. So you're in a position to educate them. Many of these plans come into the mix having done years and years and years of general health insurance type work in a managed care setting, but not doing long-term care services. And as we all know, long-term care is wholly different than inpatient care and visits to doctors for sneezes, wheezes, and broken bones. Many of the managed care plans have no idea that personal care is part of the mix in Medicaid long-term service support. So that educational opportunity is there for you to then get the greatest value out of that. But I'd also encourage all of you who are interested in this field of home care to get engaged in the process of these transitions at the states, the development of the architecture that the state's using and the like, because this is the best opportunity to design it into the best possible form that would give people the advantage of having access to home care services and you the business opportunity as well. We'll move on to the next area, which is our dominant area for discussion today, and that's Medicare home health regulatory issues. Mary and I are going to share a wide range of current regulatory issues with you. As Teresa mentioned earlier, we'll be opening it up to questions after about quarter after 3. It'd be our time frame for opening up to questions is our game plan. If not before then, if we can get through it all. But we're going to talk about the Home Health Prospective Payment 2015 proposed rule, its elements that include rate rebasing and face-to-face encounter changes, therapy assessments, and much, much more. We'll also be bringing in PACOS, as a topic for discussion, the Medicare Improvement Standard, new Medicare conditions of participation, sanctions that are there, civil monetary penalties among them, as well as the potential for new conditions of participation. And then as well, we'll be referencing the moratorium on new home health agencies, and Mary and I will be splitting that up. We'll start on the next slide with the home health rate proposed rule. On that slide, you have a citation, a link to the site where you can spend your nights and weekends reading just incredibly interesting information. I consider sharing it with my family if I were you. It is something that if you're going to the beach this weekend, makes better reading than any Stephen King novel even. But on the payment rate side of it, it's really Chapter 2 of the novel on rebasing. Chapter 2 being of a 4-chapter book, a phase-in of rebased payment rates as required under the Affordable Care Act. Just a little bit of historical context. The ACA required rebasing to start in 2014. It gave the Secretary of Health and Human Services significant discretion on how it would bring about rebasing, significant but not unlimited. It did limit the Secretary to rebasing changes no greater than 3.5% of the amount that would be involved under the 2010 rates. It did not indicate that it had to reach a particular outcome, so there's plenty of flexibility that they have in the rebasing of payment rates. CMS, in last year's rulemaking, went through and evaluated what the cost was of each discipline of service, calculated also the number of visits of each discipline of service in an average episode, and put those two items together to then rebase the basic episode rate to what it considered to be average cost. In doing so, they make quite a few assumptions as to what's happening between the database year that they were using, and they used 2011 data in that rulemaking, and they made assumptions in terms of what would be happening relative to changes in costs, changes in revenue between 2011 and the effective date of 2014. In this year, they took the exact same formula that they put together last year to rebase the payment rates, achieving the full cut allowable on the base episode rate, the 3.5% of the 2010 rates, which is $80.95 cut. They also adjusted LUPAs in order to conform with what they considered to be costs, but in those cases, the LUPA increases were capped at 3.5%, and they downgraded the level of reimbursement for the second consecutive year on non-routine medical supplies as well, about 2.82% reduction there. One of the most important things to note in this proposed rule is the recalibration of the case mix weights that are there, and we'll talk some more on that. It's done in a budget neutral fashion. It is referenced in the rulemaking that the focus was on therapy related episodes with an increase of the impact of low volume therapy episodes and a decrease of the impact on the weights for high therapy episodes. Again, I'll give you some more detail on that in a moment. Bottom line is that the proposed weights became very, very confusing. They made no changes in the outlier eligibility standards. The same fixed dollar loss ratio is put in place, with CMS estimating that they would be spending about 2.26% of the 2.5% budget on outliers. Offsetting the rebasing cuts is a proposed market basket update of 2.6% and a new productivity adjustment of minus 0.4%. The productivity adjustment has nothing to do with home health productivity. It relates to non-farm labor productivity in all sectors of non-farm labor that are non-governmental sectors. So you have a net of 2.2% of a market basket index increase. This is only a proposed result. You could see the market basket index go up or down when they get to the final calculation. They'll be using another quarter, possibly 2 quarters of data from the Bureau of Labor Statistics to calculate and then project what the cost increases will be in 2015. Just a side note, an unfortunate one, though, is that there will be a 2% payment sequestration throughout the remainder of this year, but we can expect it to take effect for next year as well, for the foreseeable future. It is an annual decision of the President, but I think the decision is merely mathematical, so it will be triggered almost absolutely for certain unless they change the sequestration law. The last but not least, in terms of the general comments I wanted to make on the new rule on this slide, is the new wage index, which is a blend of the 2014 designations of core-based statistical areas, CBSAs, with the new designations, geographic designations for CBSAs. CMS is putting in a 50-50 blend in order to make it a little smoother transition for providers of services. That's consistent with what they did in 2005 as well, when the Office of Management and Budget went from MSAs to CBSAs. The big question mark, though, is what happens with those geographic areas that are rural in 2014 but will no longer be rural in 2015, as well as those that are not rural in 14 but will become rural in 15. There are a few areas of the country where that has occurred. CMS has not actually faced this issue before. They thought they had, but we've confirmed that they did not. They are not certain what they are going to do. It seems they are leaning towards allowing the rural add-on for those providers operating in 2015 rural areas, not 2014 rural areas, while we encourage them to apply it to both if it's going to be a transition. But stay tuned on that one. The next slide, just a few maybe editorial comments about the rebasing on the 4-year phase-in. We believe that it is a very faulty formula that they use for rebasing. They use proxies for episode revenue and costs. When we do a direct cost and revenue analysis, we come up with different numbers. And we also see the formula that they created as one that guarantees aggregate payments are less than the average cost. The reason for that statement is because they reimbursed basic episodes to average cost, but they did not rebase LUPAs to be full payment for the cost of a visit. And we also still have outliers, which are remaining unchanged, where about 52% of cost of an outlier episode is reimbursed through the current outlier formula. So we're seeing losses on outliers, losses on LUPAs, losses on PEPs as well, which they made no changes in, and that's about a 50% of cost reimbursement. Combined with the average cost reimbursement, that formula, simple math, a neutral combined with 3 negatives is a net negative. So guaranteed less than cost on average. We believe there are better alternatives, and we think that they should be including consideration of other costs. Again, we will be continuing to advocate on those points. But relative to something I mentioned earlier, the recalibration, I wanted to give some special attention to that, and that's set out in the next slide. The recalibrated rates are recalibrated unevenly. If you were to do a side-by-side of 2015 case mix weights with 2014 case mix weights and just looked at that, there is no rhyme or reason to them, and there's no way to make that rationalized just by looking at it in that way. CMS, in the proposed rule, references that they made some adjustments on the therapy variables within the case mix weight formula, increasing the weights for episodes that have 0 to 5 therapy visits by 3.75%, episodes with 14 to 15 visits decreased by 2.5%, and 20-plus therapy visits decreased by 5%. But in reality, because they didn't simply recalibrate based upon that therapy input, we are seeing episodes that have 20-plus visits actually paid significantly more than they are currently paid in 2014. If you were to look, if you were to do that same side-by-side I mentioned and add to that the base episode payment rate and do the multiplication of the two, you would find that 20-plus therapy episode cases are increasing in reimbursement somewhere between $200 and $500 an episode, depending on which of the particular HERGs that we're looking at there. So individual agencies are going to have to do an individual impact analysis using that kind of side-by-side calculation in order to determine whether a patient census that you normally experience will bring you to a point of increased or decreased revenue, and to what extent. CMS's own impact analysis is not particularly informative. It indicates that not-for-profit agencies will have a 0.6 on average increase in reimbursement, and for-profit agencies will have a net of 0.4 decrease, but it's not your tax status that matters here. It's your patient census that matters. It's your wage index area that matters, and the like. Don't be misled by the base rate change. This is a net cut. That the base rate in 2014 for an episode is $28.69.27. It will rise to, in 2015, proposed to at least, to $29.22.66. But when you factor in the case mix weight changes and the wage index changes, on average, it will be a net reduction from 2014 numbers, estimated to be somewhere about 1.45 lower than it was, and that's the end result of rebasing at the max in that way. And that's not even counting the 2% sequestration component. Now, a few other regulatory items to mention in the proposed rule. Besides being unable to spell proposed, as I see in the next slide, I left out an O. We're going to talk about the face-to-face, the therapy assessments, and the others that are listed there. And we'll start with the face-to-face and counter-proposed changes. Yes, I'll admit to the fact that we here are very pleased with the proposed change that they've offered there. We believe the home care community at large is quite pleased with it, although we still have some remaining questions about what they're proposing to do. Due to their CMS learning about the validity of the concerns voiced by home care companies all across the country relative to the difficulties with the physician narrative requirement, CMS is proposing to eliminate that requirement. The bulk of all claim denials that are being issued today are face-to-face related denials, and of the face-to-face denials, the vast majority of the face-to-face denials are being are based upon insufficient documentation, specifically the insufficient narrative. So by eliminating the physician narrative requirement, it will go a long way to taking out a headache that home health agencies have been experiencing in recent times. Just as a little footnote, it wasn't just the concerns that home health agencies had that led CMS to do this. CMS's own report card, the Comprehensive Error Rate Testing Program, the CERT testing program, showed a real surge in errors by Medicare contractors in initially paying for claims on the face-to-face type issue that were later denied with retroactive impact. So CMS wants to improve its own report card too, and we don't blame them that it doesn't seem anybody could figure out what a sufficient narrative was. Also, they propose, though, to fill the gap by requiring certifying physicians to have sufficient records to support the certification, or if it's coming by way of an inpatient stay prior to home health, coming from that inpatient facility, having sufficient records to support the face-to-face certification that the patient is confined to the home and in need of skilled care. This is an area where we have a lot of questions that we need to get answered and get clarified. We don't know at the moment what's the state of affairs on physician records. Are they sufficient to be supporting the certification? CMS has a pretty strong position when saying doctors should not certify that the patient's homebound and in need of skilled care blindly, that they should have sufficient records in order to do that. They don't need a narrative explaining it, but do they have the clinical records from their own evaluation or others that they rely on in reaching that certification? We'd like to know, for example, will it be acceptable for home health agencies to send the physicians the documents that they all have in order to help support the physician certification? If that is permitted, it obviously will have to take place prior to the physician signing off on that certification. So a bit of clarification that we need there. They've added a little skin in the game for the physicians, but it's really, really a little bit. Because, we've talked about how the physicians have no real downside from having an insufficient narrative or insufficient support for their certification. What CMS is proposing is to reject any physician's claim for payment for certification or recertification when the home health claim is denied for non-compliant certification or recertification. As many of you know, we filed a lawsuit, NAHC versus Sebelius, on the physician narrative requirements. It's pending in federal district court in Washington, D.C. We allege that CMS has gone beyond its power, requiring excessive documentation, specifically the narrative. We do not believe the narrative was authorized by the law passed by Congress. In addition, we allege that CMS has failed to provide adequate and clear guidance to all stakeholders on what is acceptable documentation. Our conversations with the medical directors at the Medicare Administrative Contractors, just one example where the doctors are almost on a wholesale basis disagreeing with the conclusions of the medical review staff. And anybody's definition of sufficient is certainly one which is subjectively based. The third claim we have is that they fail to review the whole record. There is no reason why a truly homebound person should be denied because the doctor didn't use the right words to describe that in the narrative that is there for the face-to-face encounter. While the proposed regulation should eliminate much of what we brought that case for, that being the narrative, we still are keeping that case alive because there were large numbers of claim denials that were face-to-face related. In fact, I have in front of me some recent statistics from PGBA, Palmetto Government Benefits Administration, one of the largest of the three Medicare contractors. And in April, in January through December 2013, they denied 390 claims based on face-to-face in Alabama, 2,036 in Florida, 1,152 in Illinois, 1,504 in Texas, and hundreds more in other states where they have their territory. The denials have gone down since that time. Now in April to June period of 2014, we see, for example, only 219 claim denials out of the 1,300 they reviewed that are face-to-face related. But we're definitely looking at seeing a way to protect those providers affected by those earlier denials. In addition, this proposed rule change, the normal schedule would have it take effect on January 1st, 2015. That means that we could still find Medicare contractors looking at these claims and denying them for the same bogus reason up until January. So we're looking to see if we can find a way to remedy the existing audits as well. On the next slide, just a quick note to tell you, around the bend is the Medicaid face-to-face rule. It's on the unified regulatory agenda for coming out in October, but we really don't know when it's going to come out. Medicaid officials tell us they're still waiting for the dust to settle around the Medicare side of it, although states do have the opportunity to put it in if they want along the way. Just a couple more notes before I pass it on to Mary. One is they have a little bit of a hidden trap. They're proposing a clarification around when a new start of care begins for a patient that is discharged from a home health agency with goals met. It would, in their estimation, increase the number of starts of care and face-to-face requirements by 837,000. I have a hard time believing that number. Mary can have some comments about that too, but that is obviously tied into the face-to-face requirement. On the next slide, the new CMS idea that they put forward is not something that's immediately coming at home care, but it's definitely on the horizon. CMS put forward basic architecture on value-based purchasing, requesting input from anybody who's interested. They are suggesting that a value-based purchasing model focusing on 5 to 8 states that would be selected. It would be mandatory in those states. They would withhold from the provider payment somewhere between 5 to 8% of the payments made to the provider, and then establish a sliding scale of bonuses and penalties, meaning you're not getting the money back based upon performance and improvement in performance measures. They do not outline what those measures are. and they do not outline how they would distribute some of the withheld money. Would they distribute all of the withheld money or not is not even stated. But the most concerning part of this is the 5 to 8% of payment that they put at risk. Just to compare to the hospital's value-based purchasing program, the hospital's VBP program is being phased in to a maximum of 2%. It's currently at 1.25%. If they were to withhold 8%, that would mean that at least half of the providers of services under current information of where they are in costs would be paid less than their direct costs of care while waiting to see if they qualify for a bonus payment. We at NAHC are supportive of volume-based purchasing as a new way to deal with the delivery of Medicare services. We do not believe that a 5 to 8% is a good starting point for any kind of program that has a withhold. And then a couple of comments on three more items. The new Medicare coverage guidelines, the Jimmo versus Sebelius settlement, it focused on the illegal improvement standard as some Medicare contractors were using. I had actually litigated this issue back in 1987 as a class action against the Medicare program. It led to rewriting all of the regulations, eliminating the improvement standard, and focusing in on one thing and one thing only. Does the patient need skilled care, regardless of whether they are acutely ill, chronically ill, need care for a short term, for a long term, whether they are improving or can be improved, or whether you're dealing with a maintenance of function or a slowdown and deterioration of an individual. So the settlement of that case was fairly swift by the Medicare program. One ironical thing that has just come out this week in information is that Ms. Jimmo, the first-name plaintiff in this class action case brought in Vermont, has filed a new lawsuit because as part of the settlement, her claim was reopened and reevaluated without regard to improvement, and her claim was once again denied. In this case, it was denied on the basis that she did not need skilled care. So her attorneys have filed another lawsuit on her behalf to try to protect her interest in Medicare coverage. Quick comment on the next slide, compliance on focus on home care. Home health care Medicare is the only sector in Medicare that has 4 different contractors looking at their claims. That's a darn strong message to all of you that you better have everything perfect for when, whether it be the MAC, the ZPIC, the RAC, or the Supplemental Medical Review contractor comes knocking. And Medicaid is also finding its way on the compliance agenda. No reason to talk about the high-level fraud stuff because I got a feeling that nobody who's connected to the alliance is actively committing a felony like we're seeing in some places where they bill for phantom care. My last comment is on the moratorium on new home health agencies. I give you the link on that next slide to the Federal Register publication on the moratorium. No new home health agencies are being allowed in Miami-Dade County in Florida, Cook County in Chicago, and recently added are Dallas, Houston, Detroit, and Fort Lauderdale. These are for new providers. There can be changes of ownership still. You're allowed to relocate within the area. You can't locate from outside of the moratorium area into the moratorium area, but you can relocate from inside the moratorium area to somewhere else within the moratorium area. If you're a home health agency and looking to establish a branch in the moratoria area, whether you have a parent office in the moratoria area or outside it, you're not going to be able to establish a branch. We don't agree with CMS on that particular position because the branch is supposed to be operational within the existing service area of a home health agency, so it shouldn't create the issues that the moratoria is attempting to address. And the big question is, what's going to happen at the end of this month? The 6-month moratorium in all those areas will run out at the end of this month. My own prediction is that CMS will extend it in those areas at another 6 months, which is what their authority is, and that they possibly may add additional areas. If I were to forecast where they probably are looking at for extension of the moratorium, it would be in the Los Angeles area, that possibly in some of the other areas in the Midwest, like in Ohio, too. But we'll know, hopefully, by the end of this month what they're going to do in that regard. So now, what I'm going to do is take a breath, And pass the phone over to Mary St. Pierre, who will continue with discussion on the proposed rule and other regulatory matters. Mary Carr. Deepest apologies to Mary Carr for that one.
That's okay. I'll take it as a compliment. Well, thank you, Bill. I'm going to discuss the remainder of the provisions in the proposed rule, and these are the non-payment provisions. Then I'm going to go into some issues affecting home care, some key regulatory issues that are impacting home care, and will continue to impact home care in the future. The first one is the therapy reassessment. CMS in the proposed rule is proposing to replace the 13th, 19th visit and 30-day reassessment requirement with a 14-day therapy reassessment. We were actually very pleased to see this, and we were surprised to see this. We had no warning that CMS was going to do this. And CMS in the rule does discuss a couple reasons as to why they've come to this decision. One of the reasons is it did not achieve the goal that they intended. They were intending with the per-visit assessment that they would see a decrease in these episodes that reach 14 therapy visits and 20 therapy visits. And when they did their analysis, they did not see much of a difference. So they also were hearing the industry on how complex and burdensome this requirement was, and that agencies were having to write off visits where they were providing necessary therapy simply because it was such a tracking nightmare. So, again, we were very pleased to see that CMS came to their senses of sorts. And we are hearing that perhaps the 14-day time frame still may be a little narrow. So we will probably be proposing maybe a 30-day reassessment or something to that effect, something a little less than the 14-day. But we are seeking comments and very interested in hearing from therapists and agencies who have been working with the 13th, 19th therapy visit requirement and making sure that we're not replacing one difficult tracking system with another one. The next slide is the OASIS submission threshold. This particular provision relates to the pay for reporting, where agencies will have 2% reduction in the payment rates if they do not submit quality reporting. This has been in effect, I believe, since about 2007. CMS, however, never set a minimum threshold for how many OASIS assessments they would require appropriate or that they would require in order for agencies to receive the full payment rate update. As a matter of fact, our understanding was that the agency submitted one quality episode, they would get the full payment rate update. CMS has received quite a bit of criticism for this, particularly from the OIG. So, in the proposed rule, CMS ultimately wants to have a 90% compliance rate for OASIS submission in order for agencies to receive the full payment rate update. But they are going to phase this in over 3 years. The first year they will require 70%, the second year 80%, the third year 90%. Beginning in 2015 is the first reporting year. So from July 1st of 2015 through June 30th of 2016, agencies will be required to submit 70% of quality assessments, and I'll go over what a quality assessment is in a minute. That will apply for the payment year for 2017. 2018, it will go up to 80%. 2019, it will reach CMS's ultimate goal of 90%. Next slide. CMS has defined a quality assessment several different ways. They've actually described it 6 different ways. I'm not going to read each and every one of these, but I will say that in order for a non-quality assessment, essentially is a start of care or resumption care or an end of care episode that does not have a matching assessment or does not fall into one of the 6 criteria. This would make reaching certainly that 70% threshold very easy for agencies. CMS has really had multiple scenarios where they will consider the assessment a quality assessment that will go towards your threshold. Next slide. CMS has a very simple formula for calculating the threshold. It is the number of quality episodes over the number of quality episodes plus non-quality episodes times 100. So we are going to be watching this, and we're very grateful that CMS is transitioning this over 3 years. Like I said, 70% I can't imagine agencies would not be able to meet in light of the fact that they've been submitting OASIS assessments since 2000. And it is also a condition for payment as well. 80% still should be able to meet that goal. It's at the 90% that we will be watching this as the years go on to make sure that the 90% is not a too restrictive or unrealistic threshold for agencies to meet. The next provision in the rule that I want to talk about is the insulin coverage standards. CMS is going to require additional diagnosis in order to support a patient's inability to self-inject. CMS is not changing the policy for insulin coverage. A skilled nurse can still visit patients and provide insulin injections if, in fact, the patient is not able to self-inject and does not have a caregiver with whom can be taught to inject the patient. But they are very concerned that there are records that really do not have any, that don't have documentation or diagnosis that support why the patient has an inability to self-inject. So at a minimum, CMS is going to require an additional diagnosis that supports that. In the proposed rule, CMS has a list of diagnoses, and this is an inclusive list that they feel these would be appropriate, acceptable diagnoses to justify why a patient is not able to self-inject. When we have looked through that list of diagnoses, we do not believe that is a comprehensive list. There probably are many more diagnoses that should be in that list, and CMS is asking comments on whether this is a comprehensive list. For example, in my old agency, we had a patient who had a psychiatric condition who was not able to self-inject related to that psychiatric condition. There are no psychiatric diagnoses on this list, and I'm sure there are other more subtle diagnoses that should be included that are not. So anybody who's interested, we really are encouraging you to take a look at that list, to please let us know if there are some particulars that should be added. We also are very interested in hearing from clinicians and individuals who work with diabetics on a regular basis. Another provision that's in this related to the insulin coverage standard, I'm taking a sip of water, relates to insulin pens. And there's quite a bit of discussion in the proposed rule regarding insulin pens. CMS presumes that a patient who has a prescription for an insulin pen can self-inject. We disagree with that premise. Filling an insulin syringe and injecting yourself are two separate and distinct activities. And I'm sure there are plenty of patients out there who have insulin pens who still require skilled nursing to inject. CMS is, again, requesting comments on this particular provision. We are very concerned that certain patients are going to be denied services simply because they are in the possession of an insulin pen. So, again, we are seeking comments from clinicians who are working with diabetic patients to please weigh in so we can have very good comments. And actually, specific instances is what I'm looking for of patients that they know whereby might have a prescription for an insulin pen and still need a nurse to inject. The last provision under the proposed rule relates to speech-language pathologists, and that should be pathologists, not pathology. CMS is proposing to change the qualifications for speech-language pathologists to require a master's or a doctoral degree and have a state license. I've not heard anything so far from any of the speech-language pathology group that would indicate this is going to be a problem. I would imagine all speech-language pathologists probably have these qualifications, and have probably had these qualifications for many years. You have to keep in mind the COP, some of those COPs, particularly the qualifications portion of the COPs for the speech-language pathologists are probably 25, 30 years old. So, like I said, I would imagine that many of the speech-language pathologists already have these qualifications, and this really shouldn't be a burden at all. Now I want to go over some of the things that are currently happening with home health agencies, some of the regulations that are impacting agencies. And the first one I want to talk about is alternate sanctions. CMS has the authority now to impose alternate sanctions in lieu of termination when you have a condition level deficiency has been found on a survey. CMS has had this authority since last year. There are actually 5 specific sanctions that CMS could impose, 3 of which were implemented beginning last year, July of 2013. They are directive plan of correction, directed in-service training, and temporary management. I have not heard, at least from any of our members, that any of these have been imposed, but they've had the authority to do this. And just on a side note, this is something Congress had wanted CMS to do back in 1987, so this really isn't news. It's new because they finally implemented it, but we knew this was coming for many, many years now. The last two sanctions that CMS can impose, civil money penalties and suspension of payment of new admissions, will go into effect this month, beginning July 1st of 2014. CMS also has to have an informal dispute resolution process in place, which is new, and will give agencies an opportunity to informally dispute a condition level deficiency that's founded on a survey. I'm going to concentrate more in the next few slides. I'm going to talk about the civil money penalties and the suspension of payments and the informal dispute resolution, since they are new, and the two civil money penalties and suspension of payments will have the most financial impact on agencies if, in fact, they are sanctioned with one of those two. And we are concerned that civil money penalties probably will be used fairly often. So with that, on the next slide, the civil money penalties can go anywhere from $500 to $10,000 either per day or per instance. Now, per instance would be a case where a survey would come into the agency, identify a deficiency, but the agency would be able to correct it before the survey was concluded, in which case you would have a one-time assessment on that per instant deficiency. Regardless of whether it's a per day or per instant, it will not exceed $10,000 per day. I don't know if that's very comforting, but it's still a limit that you put on it. There are three ranges that CMS has identified that they will use when assessing a civil money penalty. The upper range applies to if there's immediate jeopardy in place. It will go anywhere from $8,500 to $10,000 per day. Then there's a middle range where it's $1,500 to $8,500 per day, and this would be a condition level deficiency that is directly related to poor quality patient care. Then the lower range, which goes from $500 to $4,000 per day, would be a deficiency that was cited relative to some kind of administrative or structural, for example, your OASIS submission, that doesn't have a direct patient care impact. There is a link in a couple more slides down to CMS did issue guidance in the form of an additional chapter in the state operation manual that goes through all of the hows and whys of the survey and the alternate sanctions. They also have a grid that goes through which COPs would be considered the middle range, which COPs would be the lower range. They have divided them down what would be a rate range related to whether it was a repeat deficiency, if it was a first-time deficiency. So if you look at that state operations manual, you really will see a lot more detail and a lot more granularity around when and what is going to be assessed, and it helps to clarify it a little more for anybody who's interested in looking into that. CMS will look at several determinants when they go to assess a rate. Civil money penalty, specifically the penalty itself, the amount, and that is the size of the agency and its resources. They will look to accurate resources such as cost reports and claims information to assess what the true resources are of the agency. They will also look to see if you have a QAPI program or quality improvement program. If an agency has an effective quality improvement program where they're showing that they're very diligent about making sure that they're trying to stay in compliance, that for the most part they do have a very good functioning agency, they do provide good patient care, I think this will go a long way to help keep those rates down. It will appear more like this if you do have a good QAPI program and you are found to have a deficiency out. It would speak more to this as an aberrancy as rather than an ongoing problem within the agency. So you certainly want to keep that in mind. That again, if you don't have a good QAPI program, you might want to start one and really show surveyors that you are serious about maintaining quality within your agency. Now, if you are assessed a civil money penalty, you will be an initial written notice will be provided that will go over the nature, the basis, the factors that were considered, the effective date of when the civil money penalties will begin, the amount they're going to assess you for your right to a hearing. You do have a right to a hearing for civil money penalties. You have a right to file for an appeal within 60 days after you receive your written notice. It will not delay the imposition of the sanction, but it will delay the collection schedule. So until there's a decision made, CMS cannot collect any money that they have assessed. If the agency waives the right to the hearing, they will receive a 35% reduction in any civil money penalty that has been assessed. The actual day of the effective date for civil money penalties, and civil money penalties are the only ones that have this very rigid effective date. It is the last day of the survey, and it will go until you come into compliance with the condition that for which you're being assessed, what you're being cited for. So it's the other sanctions that CMS will give you at least a 15-day notice. If you have an immediate jeopardy, at least a 2-day notice. But with the civil money penalties, it starts from the day of the survey, from the end of the survey till you come into compliance. Okay, next slide. Oh, excuse me. And you will receive a final notice that will wrap up and tell you what you're owed and the date and the due date that you owe your amount. The next alternate sanction I want to talk about is suspension of Medicare payments for new admissions. If in fact if you were sanctioned with this particular sanction, you will receive a written notice within 15 days before the effective date. It will just tell you the nature of the noncompliance, and also there's a right to appeal here, and they'll give you instructions for the right to appeal to the AL judge. Agencies must notify any new admission of the sanction, and they may not charge the patient unless they have informed them effectively, orally, and in writing, and this applies only to Medicare admissions. The next slide is the informal dispute resolution. This is in place only for condition level deficiencies. This does not apply for standard level deficiencies, and this was a welcome piece of the alternate sanction requirements. We have been advocating for this for a very long time, and it is, as it says, it's an informal. When you receive your deficiency report, you will have instructions that guide you through how you can request an IDR. You have 10 days to respond if you're interested in the IDR. It has to be the request must be in writing. And there on this slide is the link to the State Operations Manual, Chapter 10, that goes through the guidance for all of the alternate sanctions, not just these. The next slide is the conditions of participation. The conditions of participation are currently being revised. We have been waiting for them since 2006. They have been threatening to issue a proposed rule with the conditions of participation. However, they kept getting pushed back for other priorities up at CMS, but they are in OMB now. And a couple of weeks ago, an official from CMS called us and let us know that they are moving a little faster than they anticipated, and they expect them to be released late August. So that is going to be another, shot heard around the world when that one comes out. But we are fully anticipating that. We're anticipating that sooner than we thought. We were hoping to have a little breather after we submit comments to the proposed rule before we have to go right into another big regulation. But it is what it is. The next thing I want to talk about is medical review. And as Bill had mentioned, there are quite a number of contractors out there doing medical review for various reasons. I'm going to go through each one and give you a little idea, a sense of what they're doing and what their purpose is. The first one is a medical administrative contractors. That's your MAC. That's your claims processing contractor. We're all familiar with that. They can do prepay or post-payment review. They do their own data analysis, come up with where they feel vulnerabilities are, and establish certain areas that they're going to be reviewed. They can do a provider-specific. They will actually target a specific agency or agencies, or they'll do service-specific. Well, they'll look at a particular area, say a HIPS code that they think is vulnerable, or high therapy visits, and they think that those claims may be subject to overpayments or abuse. Like I said, they're probably the ones that agencies are most familiar with, the ADRs coming from the MACs, but I will say that we are seeing an uptick in general from all the contractors in medical review, and I would say this is going to be the norm. This is not an aberrancy. This is probably going to be the normal course of business. mainly because there are many contractors out there, and CMS is very motivated with pressures to control fraud and abuse. The second one, the recovery audit contractor. The recovery audit contractor became a permanent program, I think, back in 2009 or 2010. This contractor, I say, is probably one of the most transparent of all contractors, only because their contract requires them to be. They do have to vet any issue that they want to review through CMS. They have to get CMS's approval. They have to post the issue on their website and any issue that they've been approved for that they're going to start to review. They have to have a process to discuss the conclusion of a review before they submit the determination to the contractor for an overpayment. They are paid on a contingency basis, which makes it so CMS should be controlling them a little better. They're the only ones that we're aware of that are paid on a contingency basis. They are in the process right now of a new procurement phase. I believe it's going to be completed in August. I'm not sure, but I'm having a hard time finding out specifically when they tend to award these new contracts. But they are currently awarding a new contract. There were 4 RAC contractors. I anticipate there will continue to be 4. The country's divided in 4 sections, and each RAC has a section. In this new procurement, though, there will be one of the RACs will be assigned for a nationwide home health review. So instead of all 4 contractors being able to review home health, one contractor will be assigned to do nationwide home health reviews. So we can only anticipate that if we have one contractor concentrating on home health, we are going to see more reviews from the RAC for home health agencies. Right now, Conley seems to be the one that's doing the most. The other 3 contractors we have not heard much activity, so I would not be surprised if Conley gets that contract for home health, if in fact they are awarded the contract again. Then the zone program integrity contractor, they're the ZPICs, and they are specifically for fraud, and they get their information from multitude of resources. It can be the MAC, it can be the OIG. They do their own data analysis to come up with what they consider to be fraud. But if you see a ZPIC, if you get a record request from a ZPIC, it is specifically for fraud. They don't do just routine vulnerabilities. And I know agencies have been receiving ZPIC audits, so home health is on the radar with them. The next one is the supplemental medical review contractor, and they are the newest one. They're only about a year or so old, and they kind of snuck up on us and everybody else. The only contractor we're aware of that is doing reviews under this supplemental medical review contract is Strategic Health Solutions. According to their website and according to CMS' website, all the topics they review are under the question to the discretion of CMS. Well, what we have recently learned is what CMS has done is given them broad authority to review any topic that has been the subject of an OIG or a GAO report that identifies overpayments or vulnerabilities. They don't vet each individual audit through CMS. As long as it's based on an already identified issue in an OIG or GAO report, it is fair game. And we found this out the hard way when the New England states were under a review for a waste of submission that was the subject of an OIG report that came out in March. And what the subcontractor was doing was they were requesting agencies to submit medical records back from 2010, so they were reopening claims that were 4 years old. They were looking for validation that an OASIS was submitted prior to the claim being dropped. However, the validation reports are only kept on the state repository for 1 year. Once that year is gone, the 360-day, it is purged. It cannot be obtained or retracted in any way, shape, or form. It is gone, purged. Agencies are not required to keep validation reports on file. They are recommended to keep them on a year, so there would be no way to validate going back 4 years. Also, the fact that they were requesting the entire record with the intent to review the whole claim again 4 years later. Bill and I did find somebody at CMS who successfully intervened. Right now, that audit is on hold. and this is when it came to light exactly how this particular contractor functions, that they have a little more authority, a lot more authority than we would like to see them have. And CMS doesn't seem to be keeping tabs on what they're doing unless somebody informs them. So that was very eye-opening for us. And these, because of that, these have been some of the least transparent of contractors. The last one is the comprehensive error rate testing contractor, and that's the one Bill spoke of. They are actually do error rate testing on the MACs. They are CMS's watchdog. And CMS is very concerned about the error rate that the CERT come up with because it tells CMS that they are not doing their right job. It was the CERT review of face-to-face that started this broad face-to-face review from all the contractors that we have been dealing with for the past year. So the CERT contract has a lot of weight with CMS. If they say there's an error, they respond to it, and they are very concerned in getting it under control if a CERT contractor has identified it. CMS recently just issued a change request 8690, and this change request will require the MACs and the supplemental medical review contractors to post their issues on their websites. The MACs, some of the MACs are better than others. I mean, and they're kind of inconsistent too. So this will require that they do submit, that they do post whatever reviews that they are conducting, and the supplemental medical review contractor must also post the OIG or GAO report with which they are referring the audit from, or that triggered the audit. Okay, next slide is PACOS. PACOS went into effect in January of 2014, and these are edits on the ordering firm physician on claims to ensure that they have a valid enrollment record in Medicare. Beginning this month, both the attending physician who signed the plan of care and the certifying physician will have to be listed on the claim as well, along with their MPI, if in fact they are two different physicians. Obviously, this speaks to one physician is being discharged from a facility, and the facility physician is conducting the face-to-face encounter and certifying the patient and handing the patient over to the community physician who will sign the plan of care. If that is the scenario, then both of those physicians will need to be enrolled in Medicare, and they will. Well, they always would need to be enrolled in Medicare, but now they will be subject to the audits, to the edits. Both of the physicians will be. Regarding PACOS, I really thought this would be more of a fiasco than it's turned out to be. It's actually been rather smooth. I'm not hearing a lot of problems with it. There are two big issues that I'm hearing with PACOS, and that is physicians seem to be dropping off of the ordering referring list. The ordering referring list is a list on CMS's website. It's the only list that an agency can go to see if, in fact, the physician has an active enrollment record in Medicare, and then they know this physician's active. We can take orders from them and claims with their name on it. The CMS is still in the last leg of a revalidation project that will go through March 2015. Apparently, they're still revalidating many physicians, and what we're finding out is agencies are calling and saying, this physician dropped off suddenly. I looked at the ordering referring report. They were there yesterday. They're not there today. We can't figure out what's going on. Well, what we have found out is these are physicians more than likely that have not responded to the revalidation request. If they do not respond within 60 days, they are deactivated and they will drop off this list. So we are encouraging agencies as soon as they see this to please contact the physician and let them know. CMS does have a website that they post every month, letters that they sent to every provider for which they've requested revalidation. So if an agency is concerned about that, they can refer to that list and confirm, yes, in fact, Dr. So-and-so was sent a letter. They have 60 days to respond, so if he drops off the list in July, you can assure that he probably would send a letter sometime in May. The other problem that we are hearing is there is a PACOS system issue where some claims are erroneously being denied, not all claims for some odd reason. There's supposed to be a fix that comes in this month, and I'm still trying to get Wolgani CMS to give me a date as to when that's going to go into effect. I have one provider that has over $200,000 suspended and related to this PACOS edit, so hopefully that fix goes into place and works. The last but not least is OASIS. OASIS C1 was to go into effect in October of this year to coordinate with ICD-10, but since ICD-10 has been delayed, CMS was forced to modify the OASIS C1. They now have an OASIS C1/ICD-9 version that agencies will start using beginning January. Agencies have been instructed to continue using the OASIS C as it exists today through the end of this year, and then, like I said, this modified version will go into effect January. There is an error on that slide. The first bullet should be OASIS C/ICD-9 version. The second bullet that goes into effect January 1, 2015 is going to be the ICD-9 version, modified OASIS C1. CMS is planning education webinars around September regarding the OASIS C1. And there are multiple grouper updates that now are going to have to take place related to the various OASIS and the delay of the ICD-10. And on CMS's website, and I have a link to that website, you can go on and see the various dates and when the various releases are going to be. And that is it for me.
Well, Teresa, we'll take any questions at this point.
That's terrific. Thank you both so much. You've just covered a tremendous amount of waterfront. So I want to thank you both for, really doing a nice job. We've already got a few questions through the Fuse webinar chat window. I want to remind everybody that if you have a question, you can enter it, and I'll go ahead and start asking some of the questions that we've received already. So this first one has to do with the FLSA companionship services rule and some of the litigation that's gone on around it. The question is whether or not, Bill, you might be able to elaborate on how the lawsuits might impact home health agencies that are compensated under fee-for-service Medicare. And I guess really the bottom line question is, what's the right thing to do, based on the status quo?
I mean, if you're a Medicare home health agency, the companionship services exemption would likely have only been used, and perhaps even on a limited basis, with home health aid services. Once the home health aides started doing more activities, exercise programs, assistance with medications, any vital sign checking and the like, there's risk that the exemption disappears anyway. The home health agencies that would have used it would have been for home health aides that provided primarily personal care services. And there are 20-some states that had already in some way either eliminated or modified the exemption. Those agencies that still are using it in states where the exemption has not been eliminated or modified, if we're successful with the lawsuit, they would continue to be able to use the exemption. If we're not successful with the lawsuit, then the agencies will have to have systems to calculate accurately hours worked and to be assured that they are paying overtime on a federal standard of 40 hours at that point. Again, I don't think we expect to see a huge amount of impact in the Medicare sphere. It's more in the Medicaid, personal care services, and private pay side.
Great, thank you. So we've got another question here. This is about Medicare Advantage plans and face-to-face. So we've got one participant in our webinar who says, wants to know whether you guys have heard anything about what the guidance is from Medicare Advantage plans. And, this person is hearing that basically Medicare Advantage plans are being told possibly that if they don't have the face-to-face requirement in place, then they should have some kind of prior authorization requirement. They're wondering whether or not you've heard anything to that effect.
Yeah, that's an overstatement of what the guidance that came from CMS is all about. Mary Carr and I had numerous conversations with CMS officials on this. Originally, with the call letter that was issued earlier this year, the plans are being told that they must have a face-to-face requirement. That explanation, that guidance was withdrawn, and instead the plans are permitted to have a face-to-face requirement if they wish, but the plans can rely upon whatever system they feel to be sufficient to maintain program integrity and accuracy in terms of the need for the patient. So a prior authorization system is one system that a plan can have, but it's not exclusively the way the plan can go. Basically, the plans have been told, we'll leave it to your discretion to determine whether the systems that you have, in whatever shape or form they are sufficient to give you confidence that doctors authorizing home health services are authorizing care for people who qualify.
Interesting.
So any plan that says they must have prior authorization, either they intentionally are overstating what they must do, or more likely they are just misinterpreting the instruction from CMS, and we could, I'm certain, get clarification to that plan that the plan can come up with another method besides prior authorization and would not need face-to-face.
That's great. Have you heard of other types of approaches they've used as alternatives to face-to-face per se, other than prior auth?
In some cases, they have post-pay utilization review, which would be sufficient. In other situations, they have some sort of a set of protocols to follow where, you know, the agency can deliver care up to a certain level without getting prior authorization. You know, so I don't know what the list is overall on it, but the bottom line standard is whatever the plan feels is sufficient is going to be considered sufficient.
Right.
The CMS has backed away from it entirely and leaves the plan to protect itself.
Interesting.
But we just completed a survey. We're actually going to go expand it outside of our financial managers group is where we'd sent it on Medicare Advantage, and from what that survey concluded, it appears about 3/4 of the plans have prior authorization.
Interesting. This next question has to do with the RAC, so I think it's probably best directed toward Mary Carr. Mary, I think you might have mentioned at one point that it looks like that there might be a specific contractor, RAC contractor that's focusing on home health. I mean, is it already the case that there's a single RAC that handles all of the home health issues, or is it?
No, right now all 4 RACs have the option of reviewing home health.
Okay. And do you see that
we've only seen activity from one of them, and that's predominantly Conley. So I don't know if the others just haven't been interested, and they probably aren't interested because they're paid on contingency, and the RACs tend to go after hospitals and physicians. Okay.
So it's just that it just happens that there's just one RAC right now that seems to be focused
that seems
on
doing it, but the others have always had the authority.
I see. Do you think that it's going in a direction where you might have just one RAC specifically assigned?
That's the plan. That's the plan. That's CMS's plan.
Okay. All right. That's helpful. Thank you. This is another question, I think, for Mary. So regarding PICOs, the question is whether the process it's supposed to be the same for the VA physicians, the Veterans Administration physicians.
They need to be enrolled. If they're ordering home care services and their name is going on the plan on the plan of care and on the claim, they need to be enrolled.
They do have a short enrollment form for them.
They have a short enrollment. There is an 855-0 that's designed specifically for physicians who typically don't order services on Medicare beneficiaries who don't bill Medicare, but occasionally will order services. For example, a VA doctor may have to go to a lab outside of the VA and order services, or is ordering home care services, or if a resident is enrolled in Medicare and they're eligible to order services. So it is designed specifically for these physicians who typically do not bill Medicare but may have to order services. And it's a very simple form to fill out, but they're still required to have an enrollment record.
One of the PACOS areas we've found is problematic is services ordered by a VA physician. In some facilities, there's one doctor that's enrolled and the rest that are not. So we've been recommending people really double-check whenever they have a VA physician referral to make sure enrollment is continued throughout the entire episode as well.
And VA, for some reason, has been very resistant. Either we really believe for the most part there has been misunderstanding. They have for a long time believed they did not need to be enrolled in Medicare because typically they don't enroll in Medicare.
Yes, since the VA also has a home health benefit that they offer, they're shooting themselves in the foot because what happens is Medicare will not pay, but then the VA will pick it up.
Interesting. Okay. It's complex environment. Those are all the questions right now from the chat window. I'm going to encourage everybody, if you've got a question, this is your last bite at the apple in these last few minutes of the webinar. But in the meantime, I'll ask you guys just a couple questions. Bill, you talked a little bit about the JIMO settlement, and I've heard a wide range of perspectives on the actual impact of the JIMO settlement, and particularly given what you said about the plaintiff in JIMO actually filing another claim. I'm wondering what you think in the end has been the actual, or is the actual impact of the JIMO settlement today.
Well, I think there's a range. There are some home health agencies that I've talked to who believe, like maybe the plaintiff's attorneys did too, that anybody would qualify for home health services and disregard the skilled care test, any chronically ill individual. That understanding is wrong among the home health agencies, but the vast majority of agencies that I've talked to said that they never applied an improvement standard themselves. They focused in on the skilled care definitions that are there in the guidelines and documented to that. But for those who are looking at it as an expansion, I believe there's confusion out there on how do you document skilled care for someone who's not improving. And it's easy to document rehabilitation progress for an individual receiving therapy. It's easy to document that a person has a wound that's healing and such. But agencies have gotten more focused on that type of documentation than they've had in terms of the skill necessary to maintain function, the skill necessary to deal with individuals with chronic conditions. So those agencies that would like to expand into the area of people who need skilled maintenance care or skilled care for chronic conditions are really looking for some guidance on how to understand the difference in the documentation for that. So I sum that all up as saying that this has been a material but only small expansion of access to care. And part of the reason for that is the agencies themselves. That's where the first gatekeeper is the home health agency. Do they accept someone into care who's not going to improve?
Mm-hmm. Right. I mean, how much guidance is there from CMS on that definition or that,
the other part is that there's been guidance for an extended period of time. When we rewrote the coverage guidelines back in the early 90s, we used quite a few different illustrations of patients like the rheumatoid arthritic who you were preventing the hands contractures through skilled therapy services, or the MS patient where you were maintaining function for that individual, or the host of chronic care patients like the Parkinson's patient where you're monitoring medications to avoid some complication, usually in this case monitoring medications that are newly prescribed rather than something that's been in a therapy for many years for the individual. So those examples are all throughout the manual. They modified a little bit of language around it. They are supposed to be having training sessions on this through their contractors. I haven't noticed if they have done that or not. I don't believe they have.
Sure.
Maybe the Alliance wants to work on that as a project, coming up with how the JIMO settlement can be best embraced. It's a frustrating thing. It's a very frustrating thing from those of us advocating on this point. I personally was really down when I noticed that this myth about improvement was coming back in again after 20 years' time.
Well, I'm happy to discuss it further with those who are interested in the topic. I do think it's a really interesting, when the settlement came down, I think you're right, maybe more was made of it than needed to be made of it.
Well, there's no doubt that the plaintiff's attorney thought that this was changing the world in incredible ways, when all it really was doing was reminding people of existing law, but they also felt that perhaps inappropriately, definitely inappropriately, that anybody who's over 65 on Medicare could say they need care and they would pay for it at that point.
Right. Well, it's important too to be able to debunk that myth. So
it is absolutely, because that myth gets out of control and moves into other areas as well. On therapy, on what is improvement. They used to have something they call the 50-foot rule, that when you could ambulate 50 feet, you no longer needed skilled therapy, or 2 weeks post-stroke, you plateaued and you could no longer benefit from skilled therapy. Those kinds of myths were pervasive back in the 80s and early 90s, and they have on occasion creeped back into the mix under the guise of norms of care.
No, it's absolutely true. It's just as important to clarify, what's the accurate kind of guidance that everybody needs to be abiding by. So, well, we're at 3:30, and I want to thank our very, very expert speakers, Mary Carr and Bill Dombi, for a tremendous presentation today. As I mentioned at the top of their presentation, we will be posting their slides on the Alliance's website, so any of you who'd like to go back and refer to the content-rich presentation that they presented today will be able to access that. In addition, we did record this webinar, and it'll take just a little bit of time, but we do plan on getting it up on the website so that if you wanted to go back and hear it one more time, you absolutely could. And with that, I want to just thank everybody for participating again today, and feel free to reach out to either me, Teresa Lee, or Jen Schiller. You can find our information on the Alliance website, and thank you again, heartfelt thank you again to both Bill and to Mary. So